Mr. Chief Justice, and may it please the court. When a defendant's testimony is paused for a long break, the trial court may tell defense counsel not to either manage the ongoing testimony as we propose or not to discuss the testimony altogether, as the United States proposes. Both rules are supported by this court's precedents in Getters versus United States. This court barred absolute no conferral orders during long breaks, but it never opined on qualified orders. It didn't opine. There is no opining on qualified orders. Indeed, Getters himself would have been fine with such an order in Perry versus Leakey. This court allowed both absolute and qualified orders during short breaks, emphasizing the importance of untainted cross-examination to uncovering the truth. So it seems like this court case, which is Villarreal v. Texas 24557, it's coming down to the question, can the judge order the attorney not to talk to the defendant or the plaintiff? Can the judge tell the attorney to not confer with their client for an overnight stay about their testimony? And there seems to be some sort of, split. It's okay for the attorney to talk to their client, but they can't coach their client. They can't tell the client what to say. So that's the biggest thing, is that you can't coach. You can't coach them. You can't, say you got to say it this way or say, well, you can get your facts straight, then distort them at your leisure, right? But get your facts straight. And so they're kind of saying, well, no, they can't even tell you that. There's lawyer-client privilege, and lawyer-client privilege. I get to talk to my client after a day. There's plenty of things to talk about. You might be able to say don't coach them, but we get to talk about the tenor. We get to talk about the subject. We get to talk about what questions are going to be asked in the future. We could ask them how they felt about their own testimony. You could ask them, what would you have liked to have said? Is there anything else you would have liked to have had? Is there any questions you want me to ask of you during your testimony? There's a lot to talk about that isn't just coaching. Ultimately, you both want to win the damn case, so to have a conversation about, not just winning, but to get the truth out, to make sure that the testimony and the truth is crystal clear, to make sure that people totally understand, your perspective, your side. Indeed, Getters himself would have been fine with such an order. Perry reconciled its holding with Getters by noting that there is a constitutional difference between discussing ongoing testimony, which is not protected, and discussing other trial-related matters, which is protected. So you can't talk about ongoing testimony versus trial-related matters. Why can't you talk about ongoing testimony? Isn't life just one big ongoing test-a-fucking-money motherfucking non-stop motherfuckers just saying shit and saying more shit? As long as protected matters can be discussed, the right to counsel is preserved. Moreover, by allowing qualified orders, Perry necessarily recognized that counsel can indeed navigate such orders during short breaks, and there is no logical reason why they could not do so during long breaks as well. Accordingly, qualified orders allow trial courts to balance what the Constitution actually protests with the integrity of the trial, and that's exactly what happened here. I welcome the court's questions. Justice Thomas, after the night passed and there is you had testimony by petitioner, was there some objection to the judge's order in the sense that petitioner said, or his lawyer said, that they were not allowed to discuss the matters other than testimony? Not at all, Your Honor. When they came back the next day, the trial court asked them if there was anything to bring up. They said nothing. They said nothing from the defense, Your Honor, and they never filed a motion for a new trial. And in fact, not only that, on top of that, my friends on the other side, they say the only way to enforce these orders is to say, well, What did you talk about last night? But that didn't even happen. The trial court just started his testimony up the next day and everybody went on. It was assumed that they followed the court's order. Justice Gorsuch, Mr. Warthen. I appreciate the subtlety of Texas's position as compared to the Solicitor General's more absolute rule, and I just have a couple of questions about that distinction. Yes, Your Honor. First, is there any reason why the court needs to reach the Solicitor General's more absolute rule in this case? Mr. Warthen, the only reason you would have to do that, Your Honor, is if you read the order actually given in this case more broadly. Justice Gorsuch, I think that's right. That would be the only reason why we'd have to reach the government's position. Warthen, You agree with that? Yes, okay. And then, if you read it the way we read it, it would only be a managing order, no managing order, and not a no testimony order. And when we come to that, you've got, I think, the relevant language at page 23 in your brief where the court says that, well, actually, where we said in Perry that an overnight recess that would encompass matters that go beyond the content of defendant's own testimony, matters that the defendant does have a constitutional right, those are protected. If we understand the trial court's order in this case to be consistent with that standard, is there any reason why we need to address the Solicitor General's proposal? No, I don't believe so. Okay. If you believe it was just if this is a small, like, I guess you could conceptualize like this. If this is broad, this is a narrower kind of order, give me your best reason why that's the case here. That this is a narrow order? Yeah. Well, so, if you look at page 7A of the appendix, he says, I don't want you discussing what you couldn't discuss with him if he were on the stand in front of the jury, his testimony. I'm not sure whatever else you would like to talk to him about when he's on the stand, but ask yourself before you talk to him about something, is this something that manages testimony in front of the jury? And I think what he's saying here is the only thing you'd want to do while he's on the stand testifying is go up there and say you need to slow down, you need to stop shifting, you need to look at the jury in the eye, you need to remember the things that we talked about as far as the things you should say. Here are the questions I'm going to ask you next. That's all managing in the way we define it. And then he tells them, just ask yourself, when you're talking to him tonight, you could talk to him about something, and even gives him an example, potentially, if they go into a punishment phase, you could talk to him about something, but if you're going to be managing his testimony, you can't do that. And as Justice Thomas pointed out, there were no questions or follow-up clarification. Exactly. Request from counsel on that. Exactly. He gave a little bit more clarification on his own after that, but there is no question about, well, can we talk about perjury if that's maybe a thing? Can we talk about a potential plea bargain? They didn't ask any of that. Thank you, Mr. Warthen. Counsel, let's say the defendant and the lawyer go into their, wherever for their evening recess, and the defendant says something like, counsel, you remember when we were preparing for this, we both agreed we should try to get the jury to focus on Fred, and whenever it's reasonable, I should mention Fred, and I've been doing that, and I notice every time I do that, juror number 8 gets a big frown and shakes his head. He doesn't look to me like he likes the idea of talking about Fred at all. So I think that's a bad idea. Now, talking about Fred was your idea. Do you still think it's a good idea? Can the lawyer respond to that question? No. They would have to tell them, I'm under a court order not to answer that.